Good afternoon, ladies and gentlemen, and welcome to Disabilities. I'm your host, R. Michael Schlesinger, and today we'll continue our series on the IEP. Today we're going to be talking about your rights under IDEA. And basically, there are 15 rights which you and your child have. And I think it's important to know what those rights are. And we're going to insert a chart at this point, and I'm going to go into each of the rights just very briefly. And always remember that you can refer back to my book, Navigating the IEP Process. Let me go ahead and start. Access to educational records. You have the right, as parent of the child, to see the copies of your child's records. They cannot deny you. And it is the law. It is something that is not just pulled out of the air. You have the right to see anything that pertains to your child. Independent evaluation, the IEE. What happens is, if your child is denied the IEP, you will have to get an independent evaluation. What happens is, you do this out of your own pocket. You choose the person with the qualifications that is deemed necessary. It can be costly, and also be aware that the district may tell you they may not accept, you can have the evaluation done, but they may not accept the results. And that's quite highly unlikely, but it could happen that way. Parent participation is key in the IEP. Because you know your child well, you should make sure that you are an active part of the IEP team. You should identify your child well with his or her strengths and weaknesses. Let the team get to know your child through you. Prior written notice is something that is very, very important. What happens with prior written notice is that before anything can be done to your child's IEP, either additions, corrections, or deletions, the school district must write you a letter and tell you exactly what is going on with your child's IEP. And they must tell you when it will happen and what action they're going to take. And without that notice, they cannot take that action. Procedural safeguards notice is like prior notice. What happens is the district gives you notice of the procedures they're going to follow. They have to say, we are going to do X, Y, or Z with your child, and you have to give consent. So your consent is key, but at the same time, they have to write out the procedures that the district is going to follow. Understandable language. Understandable language means, in simple English, that the IEP must be written in a language that is understandable to you and the IEP team. So if you understand English, then the IEP has to be written in English. If you only understand Spanish, then the IEP has to be written in Spanish and in English. The team has the English copy. The Spanish-speaking parent would get the Spanish copy, of course. That also means that it also has to be, if someone is blind, it must be written in Braille as well. Confidentiality of information means that all of your child's information is kept confidential, and nothing can be released unless there is probable cause or by subpoena or under the law. It's all held very confidential. Informed or parental consent. This is key. No matter what you're doing in the IEP process, you must give your consent, even to have the IEP written. If you don't give consent on something, the district cannot do it. Now, there are certain times when the district can step in and say, yes, we can do that, and that is if they are giving standardized tests to other children at the same grade level at a particular time. You also have something called stay put rights. What that means is, if you are disputing with the IEP team and they decide to take a service away, let's say it's speech therapy, and your child has been given speech therapy for a week, every week for 30 minutes, until the district can come to an agreement, that service stays in effect. Once agreed what's going to happen, then they can move it into another situation, but they cannot take or add or do anything until a decision's made, so hence the name Stay Put Rights. And due process, this is real important. If you as parents have problems within the IEP process, there is a certain procedure that is set into effect. We'll be talking about due process in another episode in more detail, but particularly in this area, you must follow the steps in the order that they lay out, and we'll discuss that more later in the chapter or in the videos. But that's very, very important when it comes to due process, because then it's to a point where you have reached a point where either side is really having problems coming to an agreement. Civil action. This means that it's like a regular suit. You are going against the school board or the school district because the IEP is not being done correctly. Your child's needs are not being met, so you've gone through the due process and you are actually doing and conducting a civil lawsuit in a court of law. Mediation. This is another part of the due process. What they do before it becomes a civil lawsuit, they try to mediate, and both parties come together, and it's usually done by an administrative law judge. They listen to either side, and they don't take sides, but they try to come to an agreement. And anytime during due process, we want to encourage parents to always get things in writing. If an agreement can be reached, get an agreement in writing and sign it by both sides. And once you do that, then you can get the IEP going again for your child. Reimbursement of attorney's fees. If it goes to where you are actually in a court of law and having a trial, depending on what side you're on, if you're on the winning side or the losing side, the judge may tell you that you can have your attorney's fees reimbursed. It will be up to the judge if and when you finally go to court. And if you've gone through all of the due process steps, one of the final steps is a state level appeal, which is beyond the district and beyond mediation, and you're actually telling people at the state level of Department of Education how the district has violated the idea and what has gone wrong. And ultimately, there is also a state complaint, which is also at the high level. If you come to a point where you cannot, through civil or any other means, come to a agreement, you would take it to the state level. And that is very, very costly, and try to avoid that if at all possible. Most of the time, it will be resolved at a lower level. So those are some of the 15 rights that we've gone over. I hope they help. And if you want to go into them more detailed and have them right at your fingertips, remember my book, Navigating the IEP Process. And you can always reach me by email, rob@specificallyspeaking. We invite topic suggestions. We invite your comments. Either email them to me, write a comment below, and please subscribe. Thanks for watching, and until next time,